In view of the above observations and finding, I need not further analyze any other submission in this regard made by the parties, and I hold that the Constitution of Shiv Sena provided by Election Commission of India, VDA, letter dated 22nd June 2023, is the relevant Constitution of Shiv Sena for determination of the preliminary issue as to which faction is the real political party. Constitution of Shiv Sena, held to be the relevant constitution, is hereinafter referred to as the SS Constitution. The leadership structure relevant for the determination. Learned Senior Advocate Mr. Kamath's submission that the leadership structure which is relevant for the purpose of deciding the preliminary issue is the leadership structure which is reflected in the communication dated 27 February 2018 and 4th April 2018 made to the Election Commission of India pursuant to the elections held on 23rd January 2018 is based on the petitioner's submission recorded in paragraph 89A to G herein above. Initially, the petitioner relied on the affidavit submitted to the ECI of the then office bearers of Shiv Sena, produced along with the affidavit in lieu of examination of chief to show that Shri Uddhav Thackeray had support of the majority in the organization. Respondents objected to such production on the ground that it is not permissible to produce affidavits of others along with petitioner's own affidavit in lieu of chief examination without the author of the said affidavits subjecting themselves to cross-examination. In any event, during the arguments, Mr. Kamath did not rely on these affidavits and limited his submissions to the 2018 leadership structure as available on the ECI website. Mr. Jethmalani, in turn, focused his submission to buttress the ground that the said leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the Constitution of Shiv Sena, which is on record of the ECI, and thus the same would be contrary to the findings of the Honorable Supreme Court in paragraph 168 of Subhash Desai. Mr. Jethmalani further relied on the legislative party leadership to submit that the legislative party also forms part of the leadership structure, as it is not only mentioned in the SS Constitution, but there is no dispute regarding the said members being part of the Pratinidhi Sabha under the SS Constitution. After having considered the submissions advanced by both the parties on the question as to which is the relevant leadership structure for the purpose of determination of the preliminary issue, I have come to the following conclusion. The submission of Mr. Kamath, the jurisdiction under the 10th schedule, only mandates a prima facie adjudication as to what the leadership structure of the political party was at the relevant time, and it does not extend to an inquiry as to whether or not the leadership structure available on the record of the ECI was pursuant to a validly held election is a correct position, and hence I concur with the same. Petitioner's submission that in these proceedings the respondents cannot challenge the organizational election results available on the record of the ECI, as the 10th schedule does not permit the raising of any such defense, is a correct position, and hence I am in agreement with the same. Respondent submission that the leadership structure of 2018 cannot be considered and relied upon for the purpose of determining the preliminary issue, as the said leadership structure is not in conformity with the Constitution of Shiv Sena, which is on record of the ECI, does not arise at this juncture, as it is a submission which has to be considered while determining whether the said leadership structure can be relied upon for the purpose of determining which faction represents the real political party, which would be dealt with at the appropriate juncture. The only question which is to be determined in the current part of the order is what and who all constituted leadership structure of Shiv Sena at the relevant time. Respondents have led detailed evidence, and despite being confronted during cross-examinations, they have been able to demonstrate that no organizational elections were held on 23/1/2018. On the contrary, in the affidavit, in lieu of examination of Chief of Shri Sunil Prabhu, PW1, has stated that organizational elections were held on 23/1/2013 and 23/1/2018. However, Shri Sunil Prabhu has not claimed any personal knowledge of the same or and whether he was present during the said elections. During his cross-examination, he was confronted with the letter dated 28/1/2013. Thereafter, a specific question was posed to him by Mr. Jethmalani as to whether he voted in the said election, to which he responded in the affirmative. The contents of the said letter clearly stated that all the candidates were declared unopposed. The contradiction was also put to the witness by Mr. Jethmalani in cross-examination. However, no justification for the same was put forth by the witness. In view of the above evidence and records before me, prima facie indicate that no elections were held in the year 2013, as well as in the year 2018. However, I, as the Speaker, exercising jurisdiction under the 10th schedule, has a limited jurisdiction and cannot go beyond the record of the ECI as available on the website, and hence I have not considered this aspect while determining the relevant leadership structure. Thus, in view of the above conclusions, I find that the leadership structure of Shiv Sena reflected in the letter dated 27 February 2018, available on the website of the ECI, is the relevant leadership structure which has to be taken into account for the purpose of determining which faction is the real political party. The question whether which faction is the real political party is discernible from this 2018 leadership structure is discussed in paragraph 112 to 131 infra of the present order. The leadership structure so determined as the relevant leadership structure for the purpose of these disqualification petitions are hereinafter referred to as the 2018 leadership structure. Since in these proceedings, both the factions are claiming to be the real political party, rival factions have emerged in the Shiv Sena. In view of the fact that rival factions have emerged and both the factions are claiming to be the real political party, it is imperative to prima facie determine when did the rival factions emerge. Thus, it is necessary to determine the relevant day on which rival factions emerged before further venturing into which of the faction was the real political party when rival factions emerged. At the outset, I must set straight the point that the determination of the Speaker exercising jurisdiction under the 10th schedule while deciding who the real political party is mandates only a preliminary inquiry which has to be done prima facie by taking into account material officially before the Speaker as the Master of the Legislative Assembly. I shall consider the facts relevant for the determination on what is before me as the Speaker of the Legislative Assembly. As noted by the Honorable Supreme Court in Subhash Desai Supra, on 21st June 2022, there was no material available before the Deputy Speaker to infer the emergence of any rival faction. However, after taking on record the resolution dated 21st June 2022, passed by the SSLP, disputed by the respondents, the very next day, the then Deputy Speaker received a resolution disputed by the petitioner dated 21st June 2022, received by the then Deputy Speaker on 22nd June 2022, contrary to the resolution dated 21st June 2022. Thus, from this fact alone, it is evident that there emerged two factions of the Shiv Sena from 21st June 2022 itself, but the same came to be officially on record of the office of the Speaker and or Legislative Secretariat on 22nd June 2022. At this juncture, it is imperative to refer to paragraph 119 of Subhash Desai Supra, where the Honorable Apex Court, while discussing the legality of the recognition of leader and the whip of Shiv Sena accorded by the letter dated 3rd July 2022 held that the Speaker ought to have taken into consideration the split that took place within the Shiv Sena, which were discernible from two sets of resolutions appointing two different leaders and whips placed on the record by Shiv Sena before the Legislature Secretariat. This paragraph into bracket 119 read with Honorable Apex Court's finding recorded by the Honorable Apex Court in paragraph 157 of Subhash Desai Supra makes it clear that the law laid down by the Honorable Supreme Court is that in view of the deletion of paragraph 3 of the 10th schedule, when rival factions emerge as a result of rift/split in the party, the Speaker has to necessarily find which faction is the real political party while recognizing leader and the whip of the party. Thus, in view of the facts recorded in the preceding paragraphs and keeping in view the principles enumerated by the Honorable Supreme Court in Subhash Desai Supra as recorded in paragraph 84 herein above, I have come to the following conclusion that the emergence of the two factions of Shiv Sena can be inferred from 21st June 2022 itself, and the same came to be a matter of official record of the office of the Speaker and of the Legislature Secretariat on 22nd June 2022.